Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. This morning, we have our announcement docket. And so when I call your name, please come forward with your attorney. If your attorney is not here, your attorney is probably in another court handling another matter, and we will wait for your attorney to arrive. If you do not have an attorney, then when I call your name, then you will come up before the bench by yourself. We have anybody ready?
Yes.
You do. Christian White. Mr. White, your full name is Christian Dominic White? Yes. Mr. White, would you please raise your right hand? Mr. White, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. White, you may put your hand down. How are you doing, Mr. White? Okay. You okay? That's good. Mr. White, your attorney of record is Attorney Bruce Smith. Attorney Smith is not here this morning. However, standing in for Attorney Smith is Attorney Jolie Shipley. Does Ms. Shipley have your permission to stand in for Attorney Bruce Smith? Okay. And Ms. Shipley, how are you doing?
I'm good, Judge. Good to see you.
Good seeing you as well. Ms. Shipley, do you waive a record in Mr. White's case?
We do.
Mr. White, I have before me on my computer a document that is titled misdemeanor information. In this information that was filed by the Jefferson County District Attorney's Office, it alleges that you, Christian Dominic White, on or about April 13 of 2024, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of assault and bodily injury. Mr. White, do you understand what you have been charged with? And to this charge, Mr. White, how do you plead? Guilty, not guilty, or no contest? Guilty. Now, are you pleading guilty freely and voluntarily? And are you pleading guilty because you are guilty? Mr. White, I also have before me on this tablet a document that is titled Misdemeanor Plea Admonishment. It's also labeled as State's Exhibit Number 1. Do you recognize this document? On page 2 of the same document, there's a set of initials, CW on the line next to a box that's checked guilty. Did you place your initials on this document? On the next page of the same document, there's a signature above the line that's titled Defendant. Is this your signature? And on the next document, that's titled Trial Court Certification, the Defendant's Right of Appeal. Do you recognize this document? And is this your signature on the line that's titled Defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? I also have a document on paper that is titled Discovery Certification. Do you recognize this document? And is this your signature on the line that's titled Defendant? Mr. White, before you sign and initial all of these documents that I just showed you, did your attorney go over these documents with you? And did you understand everything that your attorney went over? And is everything in these documents true and correct to the best of your knowledge? Mr. White, are you a citizen of the United States? State? Any,
Zero
ob-
for six one.
you have any objections to State's Exhibit 1?
No objections to state one.
Okay, no objections. State's Exhibit number 1 will be admitted. Ms. Shipley, you have advised and counseled Mr. White. Is there any evidence that he is currently mentally incompetent to stand trial?
There is no such evidence.
And Mr. White, your attorney, Ms. Shipley, has advised and counseled you. Are you satisfied with her representation? Has she provided full, effective, and competent legal representation? And your attorney, Bruce Smith, has advised and counseled you. Are you satisfied with his representation? Has he provided full, effective, and competent legal representation? Okay, Mr. White, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is that agreement?
The agreement in this case is to 1 year deferred probation, pay $400 fine, 50 hours community service, and no contact with the complaining witness until we set it up.
Okay. What's the full cost in this case? Okay. Mr. White, the state is offering that you serve 1 year deferred adjudicated probation. During the 1 year probationary period, you'll be required to pay a fine of $400 plus court costs of $277. You'll also be required to pay a probation fee of $60 a month, a urinalysis fee of $15 a month, and a reimbursement fee of $15. Your total monthly installments, that is the total amount that you will be required to pay each month, is $145 a month. Will you be able to pay the $145 each month? You'll also be required to perform 50 hours of community service, and you cannot have any contact with the complaining witness in this case, Colton Thibodeau, and you will also be required to adhere to the other standard terms and conditions of probation. Mr. White, do you understand the state's offer? Do you think that the state's offer in your case is fair and just? And do you accept the state's offer? Mr. White, I'll follow the plea bargaining agreement that you have entered into with the state. Mr. White, if you successfully complete this probationary period, this case will be dismissed. It will not result in a conviction on your record, and you may qualify for a non-disclosure. You can talk to your attorney about the non-disclosure in this matter. Mr. White, please stand next to the bailiff, follow his directions. Once you're finished following his directions, you'll be free to go and you have a blessed day. And Ms. Shipley, this is your only case.
Yes, sir.
You'll be free to go. You have a blessed day as well. Nice seeing you.
Thank you, Judge. Thank you.
Nathaniel Willie,
How are you?
I'm doing fine. Okay, this is cause number 23CCCR 1356. In case of style of state of Texas versus Nathaniel Michael Willie. Ms. Willie, how are you doing?
Doing pretty good. What's your-
I'm doing fine, thanks for asking. Willie, you represented by your attorney, Attorney Reagan Minaldi. Attorney Minaldi, how are you doing?
Good, thank you, Judge.
State is represented in this case by Attorney Andrew Hubel. Attorney Hubel, how are you doing?
Doing well, Judge. Thank you.
Ms. Minaldi, what is your announcement in Mr. Willie's case?
We have reached an agreement in terms of taking an anger management course for a dismissal. I need
Okay.
a 30-day reset to give him time to take that
Okay.
course and complete it to come back next week. Get
Okay,
receive a dismissal.
give us a reset.
December 9th.
Okay, this case will reset December 9th, 2024. Your attorney is gonna get you reset. Once you get your reset from your attorney, you'll be free to go. Stay in contact with your attorney, your bond. You have a blessed day. And Ms. Madaldi, is this your only case?
Yes, Judge.
You're free to go as well. You have a
Thank you.
blessed day. Okay, Cassandra Owens.
Applying or accepted? I was asking if you were applying or you'd already been accepted.
This is cause number 24 CCCR 1466. Case is styled the state of Texas versus Cassandra Owens. Ms. Owens, is that your full name?
Dr. Denise Owens, sir.
Okay. How are you doing, Ms. Owens?
I'm blessed, sir. How are you?
I'm blessed as well. Ms. Owens, you're represented by your attorney, Attorney Giles Cole. Attorney Cole, how are you doing?
Great, Judge.
And Attorney Cole, what is your announcement?
Ms. Owens is a veteran, Your Honor, so we're gonna apply for the,
Veterans Court?
Veterans Court, pretrial diversion.
Yes, it's Veterans Court. Let's see. Give us a reset date.
December 2nd.
Well,
What are we doing?
she's fine. Send it,
December 5th.
yeah, do the second one. She's gonna have to talk to,
The 16th, December
Okay.
16th.
this case will be reset to December 16th
Yes.
of 2024. Ms. Owens, to give your attorney an opportunity to apply for the Veterans Court program. Okay,
Yes, sir.
now, Ms. Owens, your case is gonna be reset December 16th, 2024.
Yes.
Stay in contact with your attorney, your attorney is gonna get your reset. Once you get your reset from your attorney, you're free to go and you have a blessed day.
You too, sir.
And Mr. Giles, you can get your reset.
Yes, I have
And you
one
still have another one, yes.
And they're gonna agree to dismiss that case.
Oh, when they
So,
has he played?
he's already pled in felony court,
Oh, okay,
so we talked. and-
Okay. okay.
Yes, sir.
I've been excused, Judge.
You don't need a copy of the dismissal?
Now I have a copy, do I need a copy?
If you want one, once they do it, the wizard,
Yes.
that's supposed to be,
That's
okay.
my son.
okay,
He was sent to that.
okay, I'm signing, you get it in a few seconds.
Oh, pretty cool.
I know.
Yeah. Before you finalize that other one, I think I put the 22nd. The only one we had. That was, with Jolie Schiff.
That's
Danny?
right. You know exactly what happened.
Oh, White, send White back to me. I did, okay. Okay. Okay.
I have an announcement whenever the fourth grade is over.
Okay.
I don't see you on here. You see anything for cash? I do not.
Stephen Gidry,
Oh.
this is cause number 24-CCCR 2002. Case is styled the state of Texas versus Stephen Ray Gidry. Mr. Gidry, is that your full name? How are you doing, Mr. Gidry? That's good. Mr. Gidry, you're represented in your case by your attorney, Alan Parker. Alan Parker, how are you doing?
Good, Judge, thank you.
Mr. Parker, what is your announcement in Mr. Gidry's case?
A couple of things, Judge. We're waiting on the video, and also we looked and we think, I've talked to one of the prosecutors, we think he may qualify for pretrial diversion, so we're gonna apply for that. And so we could reset it for that, and also give me a chance to get the video.
Okay, you gonna set a second week of December?
16.
Okay, this case will be reset to December 16th, 2024, to give your attorney an opportunity to apply for the pretrial diversion program. And also give your attorney an opportunity to complete the discovery, to get all of the evidence in the case. Okay? So you're gonna get your reset from your attorney. Once you get your reset from your attorney, you're free to go. You have a blessed day.
Thank you.
Mr. Parker, this is your only case. You're
Yes.
free to go as well,
Thank you.
and you have a blessed day.
Thank you.
Okay, you're welcome.
You want to give it to me? You can wait.
You want a copy, or you just sit here and maybe? Yeah.
Mr. Jeffries, I don't think your client here. Robeson, Shears Robeson, okay, okay, we'll wait for him.
I could knock out Ryan Kurtz.
Kurtz,
Maybe a three of them
okay,
knock down for you real quick.
Donna K. Denton, please come forward. He needs to go in the back if he's gonna sleep. Mr. Ibarra. You tell him to wake up, he can go in the back if he wants to sleep. This is cause number 24-CCCR 0716. Case is filed in the state of Texas versus Donna K. Denton. Ms. Denton, is that your full name? How you doing, Ms. Denton? I'm doing fine, thanks for asking. Ms. Denton, you're represented in your case by your attorney, Ryan Gertz. Attorney Gertz is not here today. However, standing in for Attorney Gertz is Attorney Benjamin Jeffries. Does Mr. Jeffries have your permission to stand in for Mr. Gertz?
Yes, sir.
Okay, Mr. Jeffries, how are you doing?
Doing well, Your Honor, thank you.
That's good. Now, Mr. Jeffries, what is your announcement in Ms. Denton's case?
We'd ask for a reset on this to review discovery.
Reset for discovery, okay. Give us a date.
December 9.
Okay, this case will be reset until December 9th, 2024. Ms. Denton, your attorney is gonna get your reset. Once you get your reset from your attorney, you're free to go.
No.
And you have a blessed day.
Thank you.
You're welcome. Thank you. Is Andrew Leonard Kledzik, he's on Zoom. Mr. Kledzik, you can take your mic off of mute. How you doing, Mr. Kledzik?
I'm doing well, Your Honor. How are you?
I'm doing fine, thanks for asking. Mr. Kledzik, you're represented in your case by your attorney, Ryan Gertz. However, Attorney Gertz is not here today. Standing in for Mr. Gertz is Attorney Benjamin Jeffries. Does Mr. Jeffries have your permission to stand in for Mr. Gertz?
Yes, Your Honor.
Okay, Mr. Jeffries, what is your announcement for Mr. Kledzik?
Again, Your Honor, we'd ask for a standard reset to give time to review discussion.
Discovery? Okay. Okay, give us a reset date.
December 9th.
Okay, this case will be also reset to December 9th. Mr. Kledzik, your attorney and your bondsman will be given notice of your reset date. Stay in contact with your attorney and your bondsman. Now, on December the 9th, you need to be here in person. And again, stay in contact with your attorney and your bondsman. You're free to go, and you have a blessed day.
Thank you, Your Honor.
You're welcome. And is Brandon Kilpatrick? Well, he's in custody.
He also has, let's see this one, concurrent with it's out of the same thing.
Attorney is, oh, I'm just looking at another note on the
Want that.
okay. And Mr.
Set for announcement to court.
Okay, and Keyshawn Dancy, is Keyshawn Dancy here?
Judge, he's present, he's outside, we're working on it, trying to dispose of that.
Okay, all right.
Judge, I have two cases ready for announcement. One case ready for one ready for a plea.
I see one, unless he's just, oh,
I'm about to send it over.
which one, on Jimmy Paul?
Yes. And Luke Cameron.
Luke who?
Cameron.
Okay. You standing in for Kyle Ringel?
Yes. For Luke Cameron.
Luke Hunter Cameron?
This case is a clear on.
Oh, this is a
This
plea?
is the plea.
Oh.
Called the announcement.
I just got it.
Oh, okay, just have a seat, okay, I thought that was. Okay. Jimmy Edward Paul? Okay, this is cause number 24 CCCR 0124. Case is styled the state of Texas versus Jimmy Edward Paul. Mr. Paul, is that your full name? How are you doing, Mr. Paul? I'm doing fine, thanks for asking. Mr. Paul, you're represented in your case by your attorney, Alec Comerford. Attorney Comerford, how are you doing?
Doing good, Judge. How about yourself?
I'm doing fine, thanks for asking. And Mr. Comerford, what is your announcement in Mr. Paul's case?
We just like a reset to review discovery.
This is on page 2.
December 9th.
Okay, this case will be reset to December 9th. 2024. Mr. Paul, your attorney is gonna get you reset. Once you get your reset from your attorney, you're free to go, and you have a blessed day. Okay? And we're still waiting on the other one. Let's see. That was reset. Robert Hebert. Mr. Hebert, your full name is Robert Hebert,
Robert John.
Robert John Hebert. How are you doing, Mr. Hebert?
Good.
Doing all right?
Yeah.
Okay, well, Mr. Hebert, let's see. I see here that currently you do not have an attorney, is that correct?
That's correct.
Let's see, did they do it? This case was just transferred over here. This affidavit. Wait up. Okay. Judgment of conviction with commitment. What is? They have something here saying judgment of conviction with commitment from February 6th of 2024. But there's nothing that's got a little lock you can click on to open it up. It says under Robert Hebert on February 6th of 2024. There's something in here that says judgment of conviction with commitment. And then 2 months later, he's appointed an attorney and an affidavit of indigency, and then an order rescinding appointment in August. And then the case was transferred to this court in August.
Yeah, there's not a document in there for the judgment.
Now, have you ever been convicted in this case? So this case never was disposed of. Is that correct? Okay. Oh, let me look at information. Of assault, bodily injury.
There's a note on there that says, it's from CC3 that says defendant did not plead, changed his mind. So they may have started the paperwork, but it
It should have
didn't.
been reviewed.
Oh, that's what it was. Okay. Now, let's see. So at one point you were appointed an attorney. Let's see who that was. Taking a while. Now it says could not download requested document. I was trying to look and see it. I was trying to see that. Actually, it was Benjamin Jeffries that was rescinded. Okay, let me see his affidavit of indigency. Oh. Let me print this off. you see that? That's an affidavit of indigence. And this was, filled out on April 3rd of 2024. Show you, document, Mr. Ibarra, did you hand this document to Mr. Hebert? Hey, Mr. Hebert, do you recognize that document? Okay, now, I have, and that's a document that was filled out, it was in April of this year.
Yeah.
Okay, I mean, it has a date on there. I think it was April 23rd or something. So let's see. Yeah, well, I'm looking April the 3rd, 2024. Now, I was looking at your, you said let me do this here. I'm gonna go off put this on mute. Court is back in session and calls number 23 CCCR 0832, case of style, the state of Texas versus Luke Hunter Cameron. Mr. Cameron, is that your full name?
Yes.
Mr. Cameron, would you please raise your right hand? Mr. Cameron, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Mr. Cameron, how are you doing?
Doing good, and you?
I'm doing fine. Thanks for asking. Now, Mr. Cameron, your attorney of record is Kyle Ringel. Attorney Ringel is not here this morning. However, standing in for Attorney Ringel is Attorney Alec Comerford. Does Mr. Comerford have your permission to stand in for Mr. Ringel?
Yes, sir.
And Mr. Comerford, do you waive a record in Mr. Cameron's case?
Yes, Judge.
Mr. Cameron, I have a document on my computer that is titled Information Sheet. Oh, did I swear you in?
Yes.
Okay. This information sheet alleges that on or about March 25th of 2023, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of assault causing bodily injury. Mr. Cameron, do you understand what you have been charged with?
Sir.
And to this charge, how do you plead? Guilty, not guilty, no contest?
Guilty.
Now, you're pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you are guilty?
Yes, sir.
Mr. Cameron, I also have before me a document that is titled misdemeanor plea admonishment. It's also labeled State's Exhibit Number 1. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there are a set of initials, LC, on a line next to a box that's checked guilty. Did you place your initials on this document?
Yes, sir.
On the next page of the same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes, sir.
And on the next document that's titled trial court certification of defendant's right of appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
At the top of this document, there's one box that's checked. The box that's checked states that this is a plea bargaining case and you have no right of appeal. Do you understand that statement?
Yes, sir.
I have another document on paper that is titled discovery certification. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Mr. Cameron, before you signed and initialed these documents, did your attorney go over these documents with you?
Yes, sir.
And did you read and understand everything that your attorney went on?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
His first name?
Mr. Cameron, are you a citizen of the United States?
Yes, sir.
Set for state one.
Any objections?
No objections.
No objections. State's Exhibit Number 1 will be admitted. Mr. Comerford, you advised in counsel, Mr. Cameron. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Judge.
And Mr. Cameron, your attorney, Mr. Comerford, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
And your attorney, Kyle Ringel, has also advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Cameron, I'll accept your plea guilty. I will find that you are mentally competent to stand trial. I will also find that your plea waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is that agreement?
The agreement is to 1 year deferred probation with 50 hours community service. This offer is to run concurrent, or this probation is to run concurrent with the felony probation in 23 DCCR 1675.
What is this court cost?
277.
Okay, Mr. Cameron, the state is offering that you serve 1 year deferred adjudicated probation. During the 1 year probationary period, you will not be required to pay a fine. You will be required to pay court costs in the amount of $277. You'll also be required to pay a probation fee, $6 a month, a urinalysis fee of $15 a month, and a reimbursement fee of $15. Your total monthly installments, that is the total amount. Let me do this here. I see this case is running concurrent. Is that with a felony case?
That's correct.
Did he get probation on that felony case?
That's correct, Your Honor.
Okay, hold on a minute. Okay, now, Mr. Cameron, state is offering that you serve 1 year deferred adjudicated probation during the 1 year probationary period. You will not be required to pay a fine. You will be required to pay court costs. And your paperwork will also show that you're required to pay $6 a month probation fee, a $15 a month urinalysis fee, and a $15 reimbursement fee, which comes to a total of $108 a month. However, because you are on felony probation, you only paid a 1 probation fee. So therefore, you'll be required to pay only $27 a month in this case. Do you understand that?
Yes, sir.
Now, will you be able to pay the $27 each month?
Yes, sir.
Now, your paperwork is going to show that you're required to pay the probation fee and the urinalysis fee. However, once you get to the probation office and they realize that you are on felony probation, they will make the adjustments. Okay, so it should come out to be around 27 a month for this case.
Sir.
Now, you are required to perform 50 hours of community service. Do you understand that?
Yes, sir.
In this case, we'll run concurrent with the felony case, cause number 23 DCCR 1675. And you will also be required to adhere to the other standard terms and conditions of this probation. Now, Mr. Cameron, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. Cameron, I'll follow the people are in agreement that you have entered into with the state. Now, Mr. Cameron, if you successfully complete this probationary period, this case will be dismissed. It will not result in a conviction on your record, and you may qualify for a non-disclosure. You can talk to your attorney about the non-disclosure because he's quite confident in those matters. Now, this will conclude your case. You're going to stand next to the bailiff, follow his directions. Once you finish following his directions, you'll be free to go, and you have a blessed day. And Attorney Comerford, I think this is your last case.
It is, Judge.
You're free to go as well.
Thank
You
you,
have a
Judge.
blessed day.
Thank you. I appreciate you, man.
Okay, you're welcome.
Correct.
Okay. Keyshawn Dancy. This is cause number M326600. Case the style of state of Texas versus Keyshawn Dancy. Mr. Dancy, is that your full name? Mr. Dancy, would you please raise your right hand? Mr. Dancy, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God? Mr. Dancy, you may put your hand down. How are you doing, Mr. Dancy? That's good. Mr. Dancy, you're represented in your case by your attorney, Attorney Nathan Reynolds. Attorney Reynolds, how are you doing?
Doing well, Judge, thank you.
And Mr. Reynolds, do you waive a record in Mr. Dancy's case?
No way.
State is represented in this case by Attorney Kyle Gasper. Attorney Gasper, how are you doing?
I'm good, Your Honor. Thank you for asking.
You're welcome. Now, Mr. Dancy, I have before me a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Keyshawn Rashay Dancy, on or about March 8th of 2020, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of failure to identify a fugitive from justice. Mr. Dancy, do you understand what you have been charged with? And to this charge, Mr. Dancy, how do you plead? Guilty, not guilty, no contest? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you are guilty? Mr. Dancy, I also have before me a document that is titled Misdemeanor Plea Admonishments. This document is also labeled as State's Exhibit Number 1. Do you recognize this document? On page 2 of this same document, there's a set of initials on a line next to a box that's checked guilty. Did you place your initials on this document? On page 3 of the same document, there's a signature above a line that is titled Defendant. Is this your signature? And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document? And is this your signature on the line that's titled Defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? I also have a document that is titled Discovery Certification. Do you recognize this document? And is this your signature on the line that's titled Defendant? Mr. Dancy, before you signed and initialed these documents, did your attorney, Mr. Reynolds, go over these documents with you? And did you understand everything that Mr. Reynolds went over? And is everything in these documents true and correct to the best of your knowledge? Mr. Dancy, are you a citizen of the United States?
State offers states 1.
Any objections?
No objection, States.
No objection. State's Exhibit Number 1 will be admitted. Mr. Reynolds, you've advised in counsel, Mr. Dancy, is there any evidence that he is currently mentally incompetent to stand trial?
None to my knowledge.
And Mr. Dancy, your attorney, Mr. Reynolds, has advised and counseled you. Are you satisfied with his representation? Has he provided fully effective and competent legal representation? Mr. Dancy, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond any reasonable doubt. State, do we have a plea bargain agreement?
Yes, we do, Your
And
Honor.
what is the agreement?
In exchange for defendant's plea, the state is offering 16 days in the Jefferson County Jail, credit for 16 days, and to tax and retire all court costs.
Okay, Mr. Dancy, the state is offering that you serve 16 days in Jefferson County Jail. However, you do not have to serve any more time in the Jefferson County Jail because you've already served 16 days in Jefferson County Jail. Therefore, you'll be given credit for the time that you've already served. The court costs in this case will be taxed and retired. That simply means that the time that you spent in jail has already paid off the court costs. Therefore, the court costs will be taxed and retired. Mr. Dancy, do you understand the state's offer? Do you think that the state's offer in your case is fair and just? And do you accept the state's offer? Mr. Dancy, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Dancy, you're gonna stand next to the bailiff, follow his directions. Once you finish following his directions, you'll be free to go. And you have a blessed day. You're welcome. And Mr. Reynolds, this is your own case. You're free to go as well.
Yes,
And
sir.
you have a blessed day.
Thank you so much.
LDD Lynch. We have, they said he was here. Who's LDD Lynch? Is it- Okay,
It's set with a felony. They
okay. Oh, there may be a felony court. Okay. Okay, Mr. Benjamin Jeffers, did you find out anything on?
Turn paperwork in for Mr. Robertson.
Okay,
We'll be getting it.
Yeah.
Robertson, okay.
I'm typing it up now.
Yeah.
Okay.
And, looking at it, and then she did come up to me, she said, I'm here, just gotta run certified.
Okay,
Mr. Dirk told me Kirkpatrick is being scheduled for trial. But
oh, Kirk, let's see, now, is he in custody?
I believe.
Kirkpatrick, yeah, he is in custody, okay. So Kirkpatrick is gonna be reset for trial in the felony court, so we're gonna reset it. They probably don't have a date that's,
He says he doesn't have a date.
okay. Okay,
Robertson, Sears, walking away, so they're here too. Robertson, Sears on page 3.
yes, here's Robertson, yeah. I think that's the one that Mr. Jeffries is,
Correct.
Yes.
He's got his felony resolved and we have turned in paperwork resolving the misdemeanors.
okay. Okay,
I sent it in.
you did. Okay, Sears Robertson,
Guess what, where he left his.
okay, this is cause number 24 CCCR 0844, case is styled the state of Texas versus Sears D. Robertson Jr. Mr. Robertson, is that your full name?
Yes, sir.
Mr. Robertson, would you please raise your right hand? Mr. Robertson, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Mr. Robertson, you may put your hand down. How are you doing, Mr. Robertson? I'm doing fine. Mr. Robertson, I have before me, you're represented in your case by your attorney, Attorney Benjamin Jeffers. Again, Attorney Jeffers, how are you doing?
Doing well, Your Honor.
And Mr. Jeffers, do you waive a record in Mr. Robertson's cases?
We do.
Mr. Robertson, I have before me a document on my computer that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Sears D. Robertson Jr., on or about February 16th of 2024, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of resisting arrest. Mr. Robertson, do you understand what you have been charged with?
Yes, sir.
And to this charge, Mr. Robertson, how do you plead? Guilty, not guilty, no contest? No contest? Now, you're pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges? Mr. Robertson, I also have before me a document on my tablet that is titled misdemeanor plea admonishment. This document is also labeled as State's Exhibit Number 1. Do you recognize this document? On page 2 of this same document, there's a set of initials on a line next to boxes checked nolo contendere, which means no contest. Did you place your initials on this document?
Yes, sir.
On page 3 of the same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes, sir.
And on the next document that's titled trial court certification of defendant's right of appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargaining case and you have no right of appeal. Do you understand that statement?
Yes, sir.
The second box that's checked states that you are waiving your right to an appeal, which means you have given up your right to an appeal. Do you understand that statement?
Yes, sir.
I also have another document that's titled Discovery Certification. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled
Yes.
defendant? Mr. Robertson, before you signed and initialed all of these documents that I just showed you, did your attorney go over these documents with you?
Yes, sir.
And did you read and understand everything that your attorney went over?
Yes, sir.
And is everything in these documents true and correct to the
Yes, sir.
best of your knowledge?
Yes, sir.
Mr. Robertson, are you a citizen of the United States.
Sir.
State offer states one.
No objection.
No objections. State's exhibit number one will be admitted. Mr. Jeffries, you've advised and counseled Mr. Robeson. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
And Mr. Robeson, your attorney, Mr. Jeffries has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Robeson, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, will we have a plea bargain agreement?
Yes, we do, Your Honor.
And what is that agreement?
In exchange for defendant's plea, the state is offering 5 days in the Jefferson County Jail, credit for 5 days, and to tax and retire all court costs.
Mr. Robeson, the state is offering that you serve 5 days in the Jefferson County Jail, but you will not have to serve any more time in the Jefferson County Jail on this case because you've already served 5 days in the Jefferson County Jail. Therefore, you'll be given credit for the time that you have already served. And the court costs in this case will be taxed and retired. That simply means that you will not be required to pay the court costs because the time that you have spent in jail has already paid it off. Therefore, the court costs will be taxed and retired. Mr. Robeson, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. Robeson, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Robeson, we'll move to the next case. The next case is cause number 24-CCCR 0856. And in that case, I have before me a document that is titled information. In this information that was filed by the Jefferson County District Attorney's Office, it alleges that you, that you, Sears D. Robeson Jr., on or about February 16th of 2024, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of criminal trespass. Mr. Robeson, do you understand what you've been charged with?
Yes, sir.
And to this charge, Mr. Robeson, how do you plead? Guilty? Not guilty, no contest.
No contest.
Now, you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the choices? Mr. Robeson, I also have before me a document that is titled misdemeanor plea admonishments. It's also labeled State's Exhibit Number 1. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there's a set of initials on a line. Uh-oh. It's not good. Like it's broke. It is. The stylus. Name. Let's try it. Oh, it worked. Okay. On page 2 of this document, he got two. I guess he was signing on the wrong.
The tablet we had couldn't erase.
Yes,
Yeah, okay.
most of them don't.
Now, on page 2 of this document, it's set of initials on the line next to boxes check no contingent. You place your initials on this document.
Yes, sir.
On the next page, there's a signature above the line that is titled defendant. Is this your signature?
Yes, sir.
And on the next document that's titled trial court certification of defendant's right of appeal. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
I also have before me a document that is titled discovery certification. You recognize this document? And is this your signature on the line that's titled defendant?
Yes, sir.
Now, Mr. Robeson, before you signed and initialed these documents, did your attorney go over these documents with you?
Yes, sir.
And did you understand everything that he went over?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
State, you like offer states 1?
State offer states one.
No objection.
No objection. State's exhibit number 1 will be admitted. And Mr. Jeffries, you advised and counseled Mr. Robeson in this case. Is there any evidence that he's currently mentally incompetent to trial?
No, Your Honor.
Mr. Robeson, your attorney, Mr. Jeffries has also advised you in this case. Are you satisfied with his representation in this case?
Yes, sir.
as he provided fully effective and competent legal representation.
Yes, sir.
Mr. Robeson, I will accept your plea of no contest. I will find that you are eminently competent to stand trial, and I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement in this case?
Yes, we do, Your
And
Honor.
what is the agreement?
In exchange for defendant's plea, the state is offering 5 days in the Jefferson County Jail, credit for 5 days, and to tax and retire all court costs.
Okay, Mr. Robeson. The state is offering that you serve 5 days in Jefferson County Jail. You've already served 5 days in Jefferson County Jail, therefore you'll be given credit for the time that you've already served. Court costs in this case will be taxed and retired. That simply means that you will not be required to pay the court costs because the time that you spent in jail has already paid off the court costs, therefore the court costs will be taxed and retired. Mr. Robeson, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just? And do you accept the state's offer?
Yes, sir.
Mr. Robeson, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Robeson, please stand at the end of that counter. You're gonna stand next to the bailiff and follow his directions. Once you finish following his directions, you'll be free to go. And you have a blessed day. And Mr. Jeffers, I think this is your last case.
Correct, Your Honor.
You're free to go as well, and you have a blessed day.
Thank you.
We have a dismissal on Juan Alvarez.
You said. We put this on the after that, late January.
Alvarez.
That's an add-on, is this?
Huh?
That's an add-on.
What is that? Alvarez? Oh.
It's gonna be 2 add-ons.
Oh,
Good morning, Judge.
good morning. Let's see. Is this Aldidi A. Lynch?
Yes.
Ms. Lynch, how are you doing?
I'm doing good, how are you?
I'm doing fine, thanks for asking. Ms. Lynch, you're represented in your case by attorney, John Cucci. How are you doing, Mr. Cucci?
Great, how you doing, Judge?
I'm doing fine, thanks for asking. And Mr. Cucci, what is your announcement in this Lynch's case?
Judge, we just set a jury trial for the felony related to this matter upstairs, across the hall in Judge Westport. And that's gonna be set, she says, for January. So
Did she give you a date?
she didn't give us a date. We're gonna get a date next week. So could we put this to late January?
Well, what we normally do, we usually just set them on the same day.
Okay, we'll know in a week, she said. Within the week, we'll know.
Right, so what we will do, we will have our court coordinator to check the computers, and then once they put the date in, we'll send notice to you and the bondsman. And you can stay in contact with your attorney and your bondsman, because your misdemeanor court date is gonna be on the same day of your felony court date. And so you
That's
just
great.
come here and check in, and then once you take care of that matter in felony court, you'll come back and let us know what happened.
Yes, thank you, Judge.
Okay,
And thank you,
So-
ladies.
all right, so they don't have a date in it, is that correct? Okay, so you're free to go? Ms. Lynch, you have a blessed day, and Attorney Cucci, you have a
You
blessed
too,
day.
Judge. Thank you. Thank you.
Okay,
Thank
you are.
Thank you.
Uh, Hey, Judge County Court, the law number 2 is back in session. The court is in session. And cause number 23 CCCR 0775. Case is style state of Texas versus Robert Hebert. Mr. Hebert, is that your full name?
Sir.
Mr. Hebert, would you please raise your right hand? Mr. Hebert, do you swear affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Mr. Hebert, you may put your hand down. How are you doing, Mr. Hebert? Okay, now, Mr. Hebert, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? You have to speak up.
Yes, sir.
Is this your signature on the line that's titled defendant?
Yes, sir.
Are these your initials on the line that state you like to apply for a court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Injuries. Do you recognize this document?
Yes, sir.
And on page 2 of the same document, there is a signature above the line that's titled defendant. Is this your signature? Now, Mr. Hebert, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
I read it,
Okay, okay, you say you didn't understand. See, when it asked for your first name, it said you put Robert. Your middle initial, you put J. And your last name, you put Hebert. Is that your full name?
yes, sir.
Okay, you have a date of birth here. I'm not gonna do that because we're on record. You said you live on McFadden. Okay, you have a phone number. You listed the benefits that you receive, you know, and whether or not you're employed. So what did you not understand?
Process, yes.
You talking about just the process of filling out the paperwork?
Yes, sir.
Okay, but you did understand the paperwork. Okay. Okay, now is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, now, Mr. Okay, now, Mr. Hebert. I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Attorney John Macy. Attorney Macy will be given information to contact you, and you will also be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be allowed to, you're free to go, and you have a blessed day. Please have a seat in that first chair on the wall and wait for your name to be called by the court coordinator.
Ready?
Yeah. Mr. Okay, this is cause number 24 CCCR 2338, case of South of State of Texas versus Mabry Maxfield III. Mr. Maxfield, is your full name Mabry Maxfield III?
Mabry Joseph Maxfield III, yes, sir.
Okay, how are you doing, Mr. Maxfield?
I'm all right, Your Honor. How about yourself?
I'm doing fine, thanks for asking. Now, Mr. Maxfield, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do, yes, sir.
Mr. Maxfield, you may put your hand down. Mr. Maxfield, you're representing your case by your attorney, Jack Lawrence. Attorney Lawrence, how are you doing?
Good morning, Your Honor.
Good morning. Mr. Lawrence, do you waive a record in Mr. Maxfield's case?
Yes, I do, Your Honor.
Mr. Maxfield, I have before me on my computer a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Mabry Joseph Maxfield III, on or about August 28th of 2024, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of criminal trespass. Mr. Maxfield, do you understand what you have been charged with?
Yes, sir, I do. sir.
And to this charge, Mr. Maxfield, how do you plead? Guilty, not guilty, or no contest?
No contest, sir.
Now, are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Freely and voluntarily and do not wish to contest, sir.
Okay, Mr. Maxfield, I also have before me on my tablet a document that is titled Misdemeanor Plea Admonishment. This document is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, sir, I do.
On page 2 of the same document, there's a set of initials. On a line next to a box, there's check no contendere. Did you place your initials on this document?
Yes, sir, I did.
On page 3 of the same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes, sir, it is.
And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Yes, sir, I
And
do.
is this your signature on the line that's titled Defendant?
Yes, sir, it is, Judge.
At the top of this document, there are 2 boxes checked. The first box is checked, states that this is a plea bargain case, and you have no right of appeal. Do you understand that statement?
Yes, sir, I
The
do.
second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
I also have a document on paper that is titled that's titled Discovery Certification. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Now, Mr. Maxfield, before you signed and administered these documents, did your attorney go over these documents with you?
Yes, sir, it did.
And did you understand everything that your attorney went over?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir. To the best of my knowledge, they are.
Mr. Maxfield, are you a citizen of the United States?
Yes, sir, I am.
Sale for state one.
Any objections, Mr. Lawrence?
No objections, Your Honor.
Okay, no objections. State's Exhibit Number 1 will be admitted. Mr. Lawrence, you advised and counseled Mr. Maxfield. Is there any evidence that he is currently mentally incompetent to stand trial?
No, not at all, Your Honor.
And Mr. Maxfield, your attorney, Mr. Lawrence, has advised and counseled you. Are you satisfied with his representation?
Yes, sir, I am.
Has he provided full, effective, and competent legal representation?
Yes, sir, he has.
Mr. Maxfield, I will accept your plea of no contest, and we'll find that you are mentally incompetent to stand trial. I will also find that your plea and waivers were freely and voluntarily given, and I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
The agreement in this case is the 55 days time served, court cost, tax, and retired.
Mr. Maxfield, the state is offering that you serve 55 days in the Jefferson County Jail, but you will not have to serve any more time in the Jefferson County Jail on this case because you've already served 55 days in Jefferson County Jail. Therefore, you'll be given credit for the time that you've already served. The court costs in this case will be taxed and retired. That simply means that you will not be required to pay the court costs because the time that you spent in jail has already paid it off. Therefore, the court costs will be taxed and retired. Mr. Maxfield, do you understand the state's offer?
Yes, sir, I do.
Do you think that the state's offer in your case is fair and just?
Yes, sir, I
And
do.
do you accept the state's offer?
I do, sir.
Mr. Maxfield, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Maxfield, you're gonna stand next to the bailiff, follow his directions. Once you finish following his directions, you'll be free to go. You have a blessed day. And Mr. Lawrence, you're free to go as well, and you have a blessed day.
Yes, Your Honor, and I'd just simply like to comment, he was in a completely public parking lot, so that takes care of that. Thank you.
Sir.
Well. Okay, okay. Now let's do this. We have this civil matter, you handling this Beltran?
It was Kobe's case, so I should be the prosecutor.
Okay, this is a form that allows him to appear via Zoom.
Okay, no problem with that.
Yeah. No, I'm just gonna get a copy of it.
Okay. Oh. There you go.
All right, thank you. Good to meet you. Good to meet you. Sure. Have a nice day.
Okay, we'll see you later.
Yes. Hopefully not, but, you know.
Okay, let's see. Okay, this is cause number M331664. Case is styled the state of Texas versus Emiliano Alcala Beltran. I have before me a motion to release property, and this motion was filed by attorney Francisco Fernandez. And I think we have attorney Francisco Fernandez on Zoom. Is that correct?
That's correct, Your Honor.
Okay. Now, how are you doing, Mr. Attorney Fernandez?
I'm doing great. How are you, Your Honor?
I'm doing fine. Thanks for asking. And the state is represented in this case by attorney Andrew Hubel. And now, hold on a minute. And just for the record, Emilio Beltran, he's not present?
He's not, Your Honor.
Okay. Was he, is he unavailable?
Well, Your Honor, with respect, this motion was filed because Mr. Beltran was originally arrested for 3 misdemeanors, which they have been adjudicated already. However,
Right.
the money that was taken from him at the time of his arrest was never released to him. So we just filed a motion to get his property back, which includes that money that was not given back to him.
Right. Now, let's see. Now, on August 30th, 2023, let's see. Attorney Roberto Salazar appeared on your behalf. Is that correct?
That's correct, Your Honor. He works in my office.
Okay. Now, at that hearing, again, Mr. Beltran did not appear. And going back through this transcript, a couple of things that I noticed. One, well, first of all, looking at the motion that was filed on August 1st of 2023, in the first paragraph, it says that the property is a United States currency in the amount of $4,294. And then in parentheses, it has $4,924.
Yes, I
And-
see that.
And at the hearing, the words from Mr. Salazar, he said, Your Honor, our client was arrested in 2020, I believe, $4,924 seized from his person as part of his arrest investigation in this case, I believe approximately 2 months ago, the case that were pending before this court was disposed of. And so the question that the court has, and somebody can answer this, was the amount $4,924 or was it $4,294? Only thing the court was presented in this case was some pictures, was a picture of some money on a table. The court was not presented with an inventory that was should have been submitted by the police department and should be in the possession of the district attorney's office. That never was presented, and the defendant wasn't here to testify to the amount of the money, and the attorney just stated, I believe it's $4,924. So, but when we look back at the motion, it has two different amounts, $4,924, where it states in the motion it's $4,294, but in parentheses, it says $4,924.
Your Honor, we'll be fine with 4,200.
But it has to be correct. We first of all, we have to verify that this money was taken from your client.
Well, that is correct, Your Honor. And with respect, we normally don't have these type of issues. Whatever amount it was, that money should have been returned a long time ago.
I understand that. I understand that, but we need to have the correct amount. And another point, at any point did your client or you and your client attempt to get the money back from the police department that seized it?
I believe my client did at some point either after he was arrested and released or after it was adjudicated.
Let me say, you say you believe that. Do we know that for a fact?
No.
In the offense report, it states the amount of currency taken is $4,295.
In the offense report?
That's correct, Your Honor.
Okay, could we, you can put that offense report into evidence? We need to have some kind of verification. So you're saying it was $4,294, not $4,924. Is that correct?
That's what I'm saying, Your Honor.
I have no objection if that is admitted as an exhibit, Your Honor.
Okay. Now, the next issue is I guess the big issue, which makes this a little bit more problematic. Hold on a minute. Oh, here we go. I guess the other issue was a little bit more problematic will be the fact that, the case was, the criminal case that is, was disposed of on May 3rd of 2023. And the court had taken judicial notice of the record in cause number M331664. And the motion was filed August 1st of 2023. And we didn't catch it the first time, but I caught it once we went back through the record. And the issue was jurisdiction. the court plenary jurisdiction ends after 30 days. Now, that doesn't affect, I think it seemed to me it should have been filed as a civil case. You would have had a different cause number, but I'm saying my criminal jurisdiction, it ended 30 days from the date that this case was disposed of. And so even if the court would, based on the research that we know, if the court would grant this from this here particular case, the court does not have a jurisdiction, which is the order would be technically void. It would be a void judgment. You understand what I'm saying?
I understand what you're saying, Your Honor. I'm not.
Because my plenary jurisdiction in this case ended 30 days after the case was disposed of. You filed this motion in the criminal case.
Okay, so Your Honor, I just don't want to be having filed a civil suit and then asking the county to pay attorney's fees when his
No,
money.
I'm not. I mean, you don't have to do that. What I'm just saying is, it seemed like it would have, because the matter probably would come back to this court. But I'm just saying that the way it's filed, you filed it in a criminal case that the court lost jurisdiction 30 days after the case was disposed of. The plenary jurisdiction ended. And so if the court signs a judgment, that judgment is void. You understand what I'm saying?
Yes, Your Honor.
So, I mean, he's entitled to his, I think seemed like the best way, I mean, it should have just been filed as just as a civil suit. And it actually, that the case still comes back here, but it comes back here under a civil deal. And, and then the court the court has jurisdiction. So I'm just saying that it's a jurisdictional issue.
Well, Your Honor, if the state's not objecting to the jurisdiction, would that order still be void?
I can look that up if the state is not objection to jurisdiction. But I know if the court does not have jurisdiction.
Just looking at the history of this case and the fact that we have a findings of facts and conclusions of the law in this case signed by both the former prosecutor, Kobe Hoffbauer, and defense, I don't think that the state would be in any objection if you can find in your research that there is
Okay.
jurisdiction.
Okay, so if there's not, the state saying that they will not be opposed. Now, the other thing is, do we have the copy of the report that's going to go, you're going to put that into evidence? And
I've marked it as states one.
States one, and Mr. Fernandez, you have any objections to states exhibit number 1?
No, Your Honor.
Okay. Okay. Okay, so we have states exhibit number 1, which is the incident report that lists the money that was seized at $4,295. Now, the other matter, hold on to this. Let's see. Now, in the order that that was sent with this case, okay, and it's the one that okay, here we go. Okay, that would have to, the amount would have to be changed. Okay. It says that the Beaumont Depot can locate property United States currency. That should change to 4,000. You have 4,294 in the wording, but then when it goes to the parentheses, it's 4,924. The above listed item in their case. Hold on a minute. I'm just trying to cross-reference to make sure that the case, the police department case number is the same It's basically 2020-02035 So zero missing, okay. These lease items are ordered, released to Emilio, kind of veteran, who's dead, okay. The property's release was property taken from the October to the above premises, okay, okay. Let's see. I think those were the questions that I had, I needed answers to. Okay, so Mr. Fernandez. The court is going to take this matter under advisement. We're just going to research that issue in reference to the jurisdiction, the state saying that they're not opposed. We just need to research that issue. And then if there's no problem in the court will sign the order.
Thank you, Your Honor. I appreciate that.
Okay. All right. Do you have any other matters that we might have to I may have to draft the order myself. Yeah. So what I'll do, if the court signs, the court will just draft the order to reflect the correct amount, and also that the monies will be released to Emilio Alcala Beltran.
Yes,
Okay?
Your Honor.
Okay, you have anything else, Mr. Hubel?
None from the state.
Anything else, Mr. Fernandez?
No, Your Honor.
Okay, you're free to go. And you have a blessed day. Thanks for being patient with us while I know you sat through like half of the docket.
I was enjoying it, Your Honor.
Okay.
Y'all have a good day. Thank you so
All
much.
right, same to you. All right, bye. Mr. Tillman. Okay. Okay. This is cause, well, you have two cases. Cause numbers CC2, cause number 24 CCCR 0548 and cause number 24 CCCR 0549. Both cases are styled the state of Texas versus Raphael Tillman. Mr. Tillman, is that your full name? Mr. Tillman, how are you doing? I'm doing fine. Thanks for asking. Mr. Tillman, you're represented in your cases by your attorney, Tom Burbank. Attorney Burbank is appearing via Zoom. Attorney Burbank, how are you doing?
Doing fine, Your Honor. Thank you.
Okay, now, Mr. Burbank, Mr. Tillman's cases is set for announcement. And what is your announcement in Mr. Tillman's cases?
Your Honor, unbeknownst to me until the other day, the notice of appointment was sent to my personal email. We have now corrected that.
Okay.
But I do need sufficient time that Mr. Tillman, is he in from this area or is he in Houston?
I don't know.
Houston.
He's from Houston?
Okay.
He's from Houston.
If he would call me maybe tomorrow or the next day and set up an appointment so he doesn't have to come over, I can go over the discovery with him and then I'll get with the district attorney to try to get this settled.
Okay. Give us a reset date. Okay. These cases will be reset to December 9th, 2024. And Mr. Tillman, your attorney and your bondser will be given notice of your reset dates. You will get your reset date here in court. Stay in contact with your attorney and your bondser. Now, there's another matter that the state would like to bring up, and just for the record, the court would like to disclose. I think the state is going to be asking for bond conditions in this case. And I think on last week, Mr. Andrew Hubel came to the court stating that there was I guess a client of yours that he was going to be requesting bond conditions on. I didn't talk to him about the facts of the case or anything of that nature. So I don't know why the state will be requesting bond conditions.
What client?
What'd you say?
What client, Your Honor?
This client. Oh, well,
This
he didn't give me no name, but I'm just putting two and two together because he did mention that the gentleman lived in Houston and his attorney was Tom Burbank. So this gentleman that's before me lives in Houston and you are his attorney. So I'm just putting two and two together.
Oh, well, sometimes I have problems with math, Judge, but it would certainly been, I guess I just received Wednesday, the 23rd at 11, something from Mr. Hubel.
He filed something?
No, it was an email.
Oh, he gave me note. He just sent me something in by the email about 30 minutes ago. Okay. Well,
I don't know.
I guess that's sufficient notice.
He say he's requesting bond conditions. I don't know. He can state to the court why and state to everyone why he think bond conditions are needed in these two cases.
Sure. These are two criminal.
Yeah, this is a criminal mischief and a burglary of a vehicle. Is that correct?
That's correct, Your Honor.
Yeah. Okay, Mr.
Okay.
So the reason why I'm requesting bond conditions in this case is that I am concerned for the safety of the complaining witness in this case. I have received correspondence from this complaining witness that the defendant has been acting in a threatening, harassing manner. I would be requesting that bond conditions be placed on the defendant so that if this behavior Continue and never see proof of this behavior, I can file a motion.
Okay, hold on a minute. Oh, hold on a minute. Um, oh, shit, hold on a minute. Do I already? Okay. I'm just trying to look back. The state is saying that they requested bond conditions because
What kind of conditions are they trying to impose, Judge?
I don't know, what you said no contact, or what are you asking for?
That's correct. That'd be asking for no contact with complaining witness in these cases.
Now, earlier you said complaining witness says plural. Is it one person or is it
No,
more
it's
than one person?
Jasmine Lawley, Your Honor.
Oh, he's talking about the complaining witness in the criminal mischief case.
And she's the complaining witness on both cases, Your
Oh, in
Honor.
both cases? Okay, so Mr. Burbank, do you have any comments?
Yeah, that's usually normal and customary in reference to these types of cases, especially if there's two instances with the same complaining witness.
Okay, give me
it's-
some bond conditions.
I mean, a no contact order would be appropriate.
Okay, so what we'll do, we'll just give us, no. You probably need to talk to your attorney before you make any statements. Okay, you have a right to remain silent. Anything that you say can and will be used against you in the court of law. And you have an attorney, the attorney could be present during any questioning. Since you have an attorney, normally people would get advice from the attorney before they make or blurt out any statements.
And in reference to that, Judge, is it my understanding from the state that the complaining witness has called or notified the district attorney's office that she no longer wishes to have any contact with my client?
That is correct.
Okay.
Okay. Okay. I can give him, I'm gonna give him a standard bond conditions that we normally give. Now, Mr. Tillman, the court is going to give you some standard bond conditions from County Court at Law number 2. And I'm going to go over these bond conditions with you. Okay, now, Mr. Tillman, I'll give you these bond conditions. It says standard bond conditions in County Court at Law number 2. Following the return of a criminal information in County Court at Law number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or against the United States. Do you understand that condition? Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to test for drugs and alcohol when directed to do so by the court, or B, submit to test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition? And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that? Now, condition number 4 does not apply. That only applies in a DWI case. Your case is not a DWI case. Now, condition number 5 does apply, and it states that the defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 Texas Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political services. Do you understand this? Now, Mr. Tillman, if you violate any one of these bond conditions, your bond can be revoked. And if your bond is revoked, a warrant can be issued for your arrest. Do you understand? Now, Mr. Tillman, you will get a copy of your reset date, and you will get a copy of these bond conditions. Once you get a copy of these 2 documents, you will be free to go, and you have a blessed day. And Mr. Burbank, your reset will be sent to you. You're free to go. You have a blessed day. Now, Mr. Tillman, stay in contact with your attorney and your bondsman. Okay, you can have a seat in that first chair. And again, thanks for being patient with us this morning.
That be excused, Your Honor.
All right, yes. And Mr. Tillman, who do you have here with you? Okay, now, Mr. Tillman, you want you to come on back up here. Now, Mr. Tillman, I know you're a young man compared to me. I'm a pretty old guy compared to you. Now, it's not uncommon for young people to say, I have friends, they have friends, they say have close friends. They use the language that this is my ride or die. This person will be with me through thick and thin. Everything, that's my friend. But on days like today, I see it's not uncommon for young men to have their mothers here with them. You know why? Because that's your ride or die. Okay? That's your friend. That's the woman who helped to put a roof over your head, clothes on your back, food on the table, right? And from time to time, I know she had the discipline. Now, I know we don't listen to everything that our parents say because, we have our own mind. But I can assure you, I tell people this all the time. Everybody not your friend. Everybody not your partner. But when that lady says she got you, she got you. Okay, so you blessed. Don't take that for granted. You are blessed to have a mother like you have, because there's a whole lot of people in this world who do not have a mother like yours. And so you should thank God for the mother that you have, taking time out from her busy schedule, because I'm sure she could have been doing other things, but she saw fit to come down here with you because she loves you. Okay, so that's a blessing. And I can tell you, Mom, hang in there with him. Okay, we've all made mistakes in life. Okay, that's just the way. And raising as a child, you probably told him not to do something, he did, right? That happens, right? But he grew up, okay, and so he's gonna mature from this situation as well. Okay, this is not the end. Okay, this is only you can use this here. Some people can look at it in 2 ways. You can look at it as a stumbling block, or you can look at it as a stepping stone. It's the same problem. You make it a stepping stone, you can use this thing and reach higher, and you can reach the goals that you have in life. All right. All right. Thanks for coming out here with your son and hanging there with him. Hang on, don't hang up. Okay. All right. All right. Yeah, you excuse Mr.
Can I be gone now, Judge?
Yeah, we can give him to. Yeah, you're free to go.
Thank you. Have a great day, man.
All right, thank you. Who? Okay, we'll be in recess. Jefferson County Court at law number 2 is back in session. The court is in session and calls number 24 CCCR 0960. Case is style of state of Texas versus Nolan Martin White. Nolan White was scheduled to be in court this morning at 9 a.m. At or about 9 a.m., the court's barely called the name of Nolan White at the courthouse door. Nolan White did not answer. Nolan White has not appeared in the court since the court has been in session. The time now is 11:58 a.m. on today's date of October 23rd, 2024. Mr. Bailiff, would you please call the name of Nolan White at the courthouse door? Nolan White? Nolan White? Nolan White?
No response, Your Honor.
Nolan White's name was just called again at the courthouse door. Nolan White did not answer. A reasonable time has passed to give Mr. White an opportunity to appear in court. He has not appeared in court. State, do you have a motion?
Statements for bond forfeiture.
That motion will be granted. Nolan White bond will be forfeited and a warrant shall be issued in cause number 24 CCCR 0960. And this will conclude, well, what happened to Freitas Zavala? Charles Rojas?
Oh, that was reset. Yeah.
Okay.
And this will conclude the calling of the court's announcement docket. Both dockets was scheduled. And the hearing docket, both dockets were scheduled on today's date of October 23rd, 2024. And County Court at law number 2, Judge Terrence Holmes presiding. Everyone, please have a blessed day. Okay, prosecutors, your excuse.
Thank you, Judge.